Um, This is the hearing in the securitization cases for Empire District Electric Company. It's file number EO-2022-0040, and it's consolidated for purposes of this hearing with EO-2022-0193. Let's begin by taking entries of appearance from the parties, beginning with Liberty.
Diana Carter and Dean Cooper for the Empire District Electric Company, doing business as Liberty.
Thank you. And for the staff?
Kurt Stokes on behalf of staff.
Okay. And for public counsel?
Nathan Williams, appearing on behalf of the Office of the Public Counsel and the public.
Okay. And for MECG?
Tim Opitz on behalf of the Midwest Energy Consumers Group.
Thank you. And Renew Missouri?
Elisa Greenwald on behalf of Renew Missouri.
Thank you. And I believe that's all the parties. As you may have noticed, and as I announced in a notice last week, we do not have a court reporter in the room with us today. Unfortunately, we were just unable to find someone able to actually fulfill that duty today. So as an alternative, we have redundant recording systems, and the transcript will, the record will be transcribed by a professional court reporter off the record that we are making today with the recording. And we have both the stream is being recorded as well as the WebEx, and we have a separate camera set up here for one marine camera that will also be recording it, so we should not have any problem with getting a redundant record. Since we don't have a court reporter here to handle the exhibits, if you do have extra exhibits that you wish to offer that have not been pre-filed, just bring them up to me. I'll go ahead and mark them. All right. I also issued a notice in this case asking people to wear masks, and I did that just because I wanted to make sure that we don't have a lot of viruses passed around today that would disrupt the hearing later in the week. I don't intend to use that. I don't want the requirement to wear a mask disrupt the hearing in any way. As I've indicated myself, when you're speaking, you can go ahead and remove your mask so that you can speak more clearly. Again, hopefully that will not cause any disruption, but I want to make sure everybody stays healthy for the end of the week. Also, going back to the idea that since we don't have a court reporter, and we're going to be relying on the recordings, it'd be very helpful for the transcriptionist if we identify ourselves when you're speaking. Obviously, if you don't have to do that every time when you're actually up here at the podium examining the witness, but if you wish to make an objection, please identify yourself so that we are clear as to who's speaking. And then we had a pending motion that was filed by staff on Saturday, I believe it was, for leave to file an out-of-time issue and position statement. Empire or Liberty responded with its statement of position as to that additional issue. Anyone wish to be heard about that issue? Mr. Williams?
Thank you, Judge. Public counsel's position is the same as staff's, and we have no objection to that issue being added.
Okay, thank you. I don't hear any other objection to the motion. Or Mr. Opitz?
I have no objection, Your Honor. I just wanted to point out MECG early this morning filed our position on that issue.
Yes. And I believe your position is the same as the company's.
I think MECG is more forceful in support of the company's direct testimony. My understanding is the company says their primary concern is the issuance of the bonds, and my primary concern is how those bonds are recovered from customers.
Okay, thank you very much. Anyone else to be heard on that motion? All right. then the motion will be granted and the additional issue is added to the list. Okay. Let's move on then to, first of all, let me identify which commissioners are on the WebEx. I know Commissioner Holtzman, you indicated you were on. Commissioner Holtzman, are you still there? Were any other commissioners on the line at this point? All right.
Commissioner Kochmeyer's here.
Thank you, sir. And Chairman Sylvia is to my left here in the hearing room for the purposes of the record.
Judge,
Yes,
if I may.
you may.
Thank you. Commissioner Roop called me yesterday to let me know that he understands how important this hearing is and to inform the parties that he's sorry that he will not be physically participating very much this week because his mother passed over the weekend. So he will be spending the next few days with his family attending to that. But he does intend to read the record and understands that as the first of its kind, it is an important case. So with that, I would ask that that everyone keep Commissioner Roop's family in their prayers. Thank you, Judge.
Thanks, sir.
Judge, Commissioner Coleman is here.
Thank you. All right, then let's go ahead and begin with opening statements, beginning with Liberty.
Thank you. Good morning. I am Diana Carter. I'm Liberty's in-house legal counsel for Missouri and Kansas. Dean Cooper of Brighton, Swearingen, England, and I are here representing the Empire District Electric Company doing business as Liberty. I will do my best just to say Liberty. I don't we need to make the distinction between Empire and Liberty in this case, as we do in some others. Liberty will have 10 witnesses appearing in Jefferson City this week. And later in my opening, I'll introduce the witnesses and outline the testimony that will be presented. But since we're making history here, as Chairman Sylvie noted, this is the first securitization hearing before the commission. So I'd like to start with some discussion on what securitization is, what the statute requires, and also what it does not require. There is the potential to save Liberty's customers millions of dollars, but a financing order in compliance with the securitization statute will be required to make that happen. I have more to say in my opening statement today than I normally do. Please stop me and ask questions if I'm losing you at some point, or you want to know what witness may be able to follow up on what I have to say, because there is quite a bit to talk about, more than we normally would have in an opening. Securitization is a financing mechanism, an alternative to that customary utility financing, and it creates two important benefits. First, it allows certain expenses that Liberty has incurred on behalf of its customers to be financed differently using low-cost bonds, reducing the amount of money that customers have to pay. And second, securitization helps to avoid rate shock, those sudden increases in customer costs, by stretching the repayment terms out longer than would normally happen. Liberty is certainly aware of the state of energy markets today and that everyone is facing additional pressures from inflation. We're looking for any way to help. When utilized carefully and for the right reasons, securitization represents a true win-win by allowing the utility to recover the costs of providing service in a way that minimizes that impact on customers. We don't get a lot of those true win-win situations, so we're really excited to be able to take advantage of that here. It's important to remember that the securitization statute does not require utilities to use this cost-saving method of finance, but Liberty wants to help save customers money and is proud to be the first to file under this new statute. You'll hear some parties in this case argue that certain costs should be disallowed, but not because of imprudence, but simply for the sake of denying cost recovery. And Brian, if you could open up the slides, thank you. You will see over this coming week that Liberty has met all required elements for securitization of the costs, both related to Liberty's retired coal plant, the Asbury coal plant, and also last year's Winter Storm Uri. The company acted prudently and properly related to Storm Uri and the retirement of Asbury, keeping stakeholders informed every step of the way. And the other parties have not demonstrated imprudence or lack of statutory compliance in any way. The Commission should recognize that Liberty has acted in the best interests of customers by seeking securitization for these costs. The Missouri Legislature passed the securitization statute intending for utilities to use it in precisely the manner Liberty proposes here. 1, to manage the recovery of unforeseen expenses, like with Storm Uri, and 2, to provide the financial flexibility to make decisions that benefit customers, as with the decision to retire Asbury. This case is an opportunity for the Commission to recognize the benefits of this new statute for utility customers, utilities, the public, and our planet. Turning to the specifics of Missouri's securitization statute, it is very detailed and prescriptive. It's not a small piece of work here. The legislature has given us the roadmap, and we need to stay on track and follow that path that they've set for us. Looking first at the definition related to Asbury's costs, these are the energy transition costs. What jumps out first at me, and when you look at subpart A, is that the retirement of Asbury by Liberty, when it was retired, must be deemed reasonable and prudent. This is clearly demonstrated by all of the testimony in this case. Now, I know the bench is very familiar with the prudence standard, looking to what was known at the time decisions were made, but since this is our first securitization proceeding and some parties disagree on how Liberty's actions should be reviewed, we brought in an expert on the topic. Liberty's first witness today will be John Reed, and I encourage you to ask him questions and discuss the proper prudence standard with him. The testimony demonstrates that the retirement of Asbury was reasonable. It had simply become economically obsolete. I would like to note here that Liberty obtained guidance from the Commission on acquiring the 3 wind farms in the initial customer savings plan docket, and then also obtained the certificates of convenience and necessity for the wind farms, all with Asbury remaining open. They were not conditioned on each other. Asbury was in rates with all costs already found to have been prudently incurred. If the Commission adopts Public Counsel's positions in this case, you'll not only be sending the message that utilities shouldn't seek securitization, but you'll also be sending the clear message that a Missouri utility should keep open a coal plant, no matter the economics and no matter the environmental impact, or else face the chance of being denied recovery of costs already expended and already deemed prudent. I'd like to remind the Commission of their own words. Not too long ago, Chairman Silvey and Commissioners Roop and Coleman issued an order in 2019 regarding another utility, saying that the Commission wanted to emphasize that they were not wavering in its support of renewable energy and that they were not wanting to dissuade Missouri utilities from retiring economically inefficient coal-fired generating plants. Liberty made the decision to retire Asbury because that was the reasonable and prudent decision in the best interests of Liberty's customers. If maximizing shareholder profits were the goal, as some have alleged, we would now have 3 wind farms and Asbury. But the right decision was to retire Asbury. There is no competent or persuasive evidence that it was anything other than reasonable and prudent to retire Asbury in 2020. Once the Commission finds the retirement of Asbury was reasonable and prudent, the listed items in the definition become costs to be financed via securitization. These include the undepreciated balance of Asbury, costs of decommissioning and restoring the site, and carrying charges. Mr. Reed, our first witness today, also testifies on carrying costs, and I'll address that issue in just a minute. With Subpart B, the Missouri legislature made it clear that the financing mechanism of securitization may be used now for plants retired before the law took effect, such as Asbury. Now, turning to Winter Storm Uri costs. Storm Uri was extreme, abnormal, and the resulting costs were extraordinary. Liberty's witnesses describe in detail the events and the company's actions that led to the company incurring these extraordinary costs. And the testimony demonstrates that the company's actions were reasonable and that the storm costs were prudently incurred. Liberty's last scheduled witness for today is John Olson. Mr. Olson and his team of experts took a very in-depth look at Storm Uri and Liberty's actions and provided detailed findings and conclusions. You'll also be able to talk about fuel costs with Liberty's Senior Director of Energy Strategy, Aaron Dole. He will be testifying today as well. Because of that extreme rate shock that could have occurred and the unreasonable financial burden that would have been placed on our customers, Liberty never sought to have the Storm Uri costs flow through the FAC with recovery over 6 months. Instead, Liberty proposed to have the extraordinary costs deferred, and the Commission authorized new FAC rates with those storm costs excluded. When Liberty filed its last rate case, the securitization statute was not yet law. But with those storm costs having been excluded from the FAC, the company proposed in the rate case to recover the storm costs over 13 years, and that, would bear the company's weighted average cost of capital. But then the securitization financing mechanism became a possibility. Those costs of securitization will be lower than the customary financing, thereby lowering the cost for our company, because you're comparing those low-cost bonds with the company's weighted average cost of capital. Looking to the specific items included in the definition of qualified extraordinary costs, we've addressed prudence separately, and so it's costs incurred before, on, or after when the statute took effect of an extraordinary nature which would cause extreme customer rate impacts. All testifying parties agree that the financing mechanism of securitization should be used for the Storm Uri costs. So we have no dispute on the majority of those elements. The next one is such as, but not limited to, those related to purchases of fuel or power. This provision in the definition is noteworthy because the option of seeking securitization as the financing mechanism is available for all extraordinary costs from atypical weather events. There's nothing specific about fuel and purchase power costs. The legislature obviously was aware of Storm Uri and made reference to it including fuel and purchase power costs to make that clear, but it's for all atypical weather events and the extraordinary resulting costs. Other parties of the case proposed disallowances from these storm costs, but without the required showing of imprudence. Staff and public counsel, in fact, admit that a primary proposed storm cost disallowance has nothing to do with prudency. Instead, they look to the 95-5 sharing mechanism of the FAC that applies in that mechanism for fuel and purchase power costs above or below the amount that's incorporated into base rates. And they ask for that to apply here. This is obviously not an FAC proceeding. The FAC statute authorizes sharing. The securitization statute does not. There's also no such sharing when you look at base rate fuel costs, because that would be unlawful absent a showing of imprudence. The FAC statute specifically provides that the Commission may include in FAC tariffs, and I quote, features designed to provide the electric corporation with incentives to improve the efficiency and cost effectiveness of its fuel and purchase power procurement activities. There is no such language in the securitization statute. This is likely because we are dealing with extraordinary costs stemming from anomalous weather events. There is no amount of incentivizing that could have effectively led Liberty to avoid the Storm Uri costs. The same would be true for the Liberty tornado in 2011 or the ice storms, again where the utilities are allowed to recover those extraordinary costs. Liberty's FAC tariff, including the 95 sharing, cannot lawfully be used to trump the securitization statute. The securitization statute has nothing that allows for extraordinary fuel and purchase power costs to be treated differently from any other extraordinary costs stemming from a weather event. The securitization statute is already designed to save customers money. Next in the definition, we have inclusive of carrying charges. Carrying charges is specifically listed in both definitions, energy transition costs and qualified extraordinary costs. These are included within the definitions, the costs that may be securitized. John Reed, who will be before you very soon, provides evidence on the appropriate regulatory standard for establishing the carrying charge for the regulatory assets for both Asbury and Winter Storm Uri. Mr. Reed and Liberty's remaining witness today, Charlotte Emery, both address the proper timing of the carrying costs. There is an issue between the company and staff as to when those carrying charges should begin. And then the last item, during anomalous weather events, again, there is no dispute that securitization should be used for Liberty's recovery of storm costs. All parties are in agreement on that point. So first we determine the amount of costs that fall within the definition of energy security costs and those that fall within the definition of qualified extraordinary costs. And now we move on to the benefits test, the comparison between securitization and traditional financing. Staff and public counsel are asking this commission to determine the amount of costs that Liberty is seeking to securitize that would be recovered through customary rate making. They appear to be asking the commission to go through a traditional cost of service rate making analysis and then compare this completely hypothetical outcome with the cost of securitization. The commission would be committing reversible error if it were to rely on that analysis. For the benefit comparison required by the statute, and this is for both coal plant retirements and weather events, the securitization statute requires a comparison of the cost to customers that are estimated to result from the issuance of securitized utility tariff bonds. And then on the other side, and it is slightly different wording, but substantially the same, the comparison is to the customary method of financing. Now, there is a requirement that the benefits test be positive, and you cannot see that there. I apologize. Everyone does have a paper copy, and of course you can take a look at this statute as well. Only Liberty and staff have weighed in on the benefits analysis, and both testify that there are significant benefits of securitization in these dockets. Using Liberty's values and calculations, we are talking at more than $70 million in estimated benefits. But I would note that the statute doesn't have a floor. There's no required amount of benefits. The statute just asks, are there benefits? Is that number positive? And again, everyone who has weighed in on this issue agrees the benefits are positive and therefore securitization should be used. So again, the statute is prescriptive, it's detailed, and there are many provisions that have to be included in the Commission's financing order in order to make this possible, in order to carry things through. And the first ones are more on what I consider our regulatory end, things that we normally deal with here at the Commission. And then there are a large number of requirements in the financing order that go more to the bond process, things that are going to happen after the financing order is issued. And that will all be addressed in a proposed financing order that the company will be putting forward. and things that are more technical in nature. But in terms of the substance of what we're normally used to dealing with here, what you're mainly looking at is just and reasonable, the prudence determination, and that benefits are expected. Based on the competent and substantial evidence that is presented to the commission, a single financing order should be issued to authorize Liberty to finance approximately $362.5 million. That breaks down to approximately $140.7 million for Asbury and $221.6 for Storm Uri. And I believe everyone is in agreement for a 13-year recovery period. Liberty has demonstrated the reasonableness of its actions, the prudence of the costs, and satisfaction of all requirements of the securitization statute, thus satisfying the just and reasonable standard and the public interest standard. As noted, only Liberty and staff have offered positions on the statutorily required benefits comparison, and both testify that substantial benefits are expected. Even when you figure in the costs of securitization, the bond process, figuring all those costs in, there is still the potential to save customers many millions of dollars if we go with securitization. So our witnesses, there will be lots of experts sitting before you this week, and I encourage you to ask them questions. In addition to our Liberty folks with the factual knowledge and the technical expertise on utility operations, and our traditional outside utility experts like Mr. Reed, we brought in a team that has done this many times before. When you're the first at something, you want to make sure you bring in people to help that have the experience. Ms. Niehaus, Katrina Niehaus, is the head of corporate asset-backed securities finance group at Goldman Sachs, where she has served as an advisor or underwriter in many securitizations. And Liberty's securitization legal counsel, Hunton, has been counsel to electric utilities, underwriters, and financial advisors on securitizations in 10 states. Hunton has also consulted on the drafting of several enabling statutes. Adam O'Brien, our Hunton attorney, who will be with us in Jefferson City this week, has worked on approximately 25 securitization transactions since 2010. We are set for 5 days of testimony. I would just like to note that James Owen of Renew Missouri is scheduled to bring up the rear. He's scheduled last on Friday. Renew Missouri has brought forward sound policy arguments in this proceeding. We often hear about how commission decisions do not technically establish precedent, but your decisions here will send a clear message. We're making history implementing Missouri's new securitization statute, and we want to make sure the correct message is sent. The Liberty team is excited to be here this week, presenting a well-thought-out plan that meets all of the requirements of the securitization statute. There is the potential to save Liberty's customers millions of dollars, and a financing order acknowledging the reasonable and prudent actions of Liberty and otherwise in compliance with all of the terms of the securitization statute will make that happen for Liberty's customers, and we're really excited to be a part of that. Thank you.
Thank you. Mr. Chairman, do you have any questions?
I do. Thank you, Judge. Thank you. Do you think this is the appropriate venue to discuss whether Asbury should have been retired in the first place?
Yes. Because, sort of, I guess I should say, Chairman Sylvie, the statute does require a finding that it was reasonable and prudent to retire Asbury when it was retired, and we don't have a commission finding on that yet. We've talked about it, as I'm sure you recall, we've talked about it in many proceedings, but we haven't actually had that finding that it was reasonable and prudent for Asbury to be retired, and that's a required part of the statute. What's not appropriate is to go back and look at the costs that were expended on Asbury when it was operating, because those have all already been determined to be prudent, and those costs are already in rates, were already in rates. So we can't go back and look at that, but we do need the finding here on the retirement.
Okay. And secondly, on your position on the, I think it was here on slide 5, just that the charges are expected to provide quantifiable net present value benefits to retail customers. Is it your position that there's no threshold up on that beyond just that it's positive?
Correct.
So theoretically, $1 justifies securitization under the statute?
Yes, technically, yes.
I
However,
understand that you're asserting that it will be millions of dollars, but
yes,
as this is the first case, I wanted to discuss that you don't believe there's a threshold beyond it being a positive number.
yes, positive when you take everything into account, which includes those financing costs and all that's involved with securitizing. So there's truly a benefit for customers.
Okay. But your position is there's no leeway for the commission to decide whether it's positive enough?
The statute certainly doesn't set a floor. Ultimately, however, it is on the commission to determine that it is just and reasonable for there to be a securitization charge. So I believe you would have certainly some discretion there on that just and reasonable determination.
Okay. Thank you. Thank you, Judge.
Okay. Then Commissioner Coleman, do you have any questions?
Hey, Judge, this is Commissioner Holzman. I just wanted to let you know that I am on, but I do not have any questions. Thank you.
All right, thank you. Commissioner Kolkmeyer? Did you have any questions? Okay, well, thank you then.
Thank you.
And for next opening statement then is MECG.
Good morning. May it please the Commission. My name is Tim Opitz, and I'm here for the Midwest Energy Consumers Group. Generally, I'm looking out for commercial and industrial customers who use a lot of power, have high load factors, and can make a difference in the utility's resource needs through curtailment during extreme events. As a little bit of background before getting into the issues here, I just want to say that Empire recently had a rate increase. Took effect on June 1st. Commission's order came out this April. There were some findings of fact there that I want to point out in that order. You included one that said, Empire's average industrial rate is in excess of 22% higher than the state, regional, and national averages. You also summarized the recent history of cost allocation for Empire's electric customers, saying, in Empire's 2014 and 2016 cases, ER 2014-0351 and ER 2016-0023, the Commission took steps to realign class rates and address the residential subsidy. However, in Empire's last rate case, ER 2019-0374, the Commission applied the rate adjustment equally across the classes due to a lack of reliable data due to the large number of estimated bills. In your order this April, you decided that the increase should be applied as an equal percentage to each class, saying that extenuating circumstances such as inflation, ongoing pandemic, were circumstances why you decided against bringing rates and cost more into parity. Here, with the rate design and cost allocation with securitization charge, I'm asking you not to make that imbalance more severe with this charge. On to the issues. Most of these issues, 1 through 7, relate to the amounts, if any, to be securitized and findings that the company needs in its order. MECG supports approval of securitized utility tariffs only to the extent there are quantifiable present benefits to securitizing those costs. But we've not yet taken a position on the amount of what those values should be authorized at. One late issue we have a position on is issue 8, and as you've gathered, that relates to the cost allocation and rate design of this charge. The question is, how should securitized utility tariff charges be initially allocated among retail customer classes? MECG's position is that the securitized costs should be allocated among retail customer classes as proposed in the company's direct testimony. Basically, the company didn't get into it, so I'll summarize it briefly. The company looked at the revenue targets by class from the last rate case, calculated that percentage compared to the company's overall revenue requirement, and then they took that percentage and applied it to their annualized level of securitized costs, annual level of securitized costs they want to recover here. I think that that's the appropriate way to do it in this case, based on the evidence that's been presented. The company also proposes using an energy figure to recover those allocated amounts. And I kind of want to make a distinction here that the securitization statute talks about allocating among the classes. So I like to think of that as the cost allocation. And then there's the second issue of the rate design, how those allocated costs will be recovered from each class. The company has proposed based on the energy charge. However, in their testimony, their surrebuttal testimony, they say they're open to additional input from parties, and the tariffs themselves will be filed after the financing order is issued, if you issue one. So I'd say that MECG prefers that the costs associated with Asbury be recovered through a kilowatt demand basis from the industrial classes. Since that amount was related to plant or a fixed cost, even if it is retired, I think that that's a cost that MECG typically prefers be recovered from a demand charge. The staff can say the reason to retire Asbury was related to wind, which the company has disputed this morning. But from MECG's perspective, those Asbury dollars were related to steel in the ground that wasn't dependent on the customer's usage. On a separate issue for the URI cost, however the commission decides to allocate that when it's designing the rates, I do recognize that the URI costs are very much fuel costs, related to fuel costs. So even though I prefer it be collected a demand charge, I'm okay using a kilowatt hour charge to collect the URI cost once it's allocated appropriately. Lastly, I want to say that the company's proposed method is consistent with the provisions of the securitization statute, specifically 393-1700.23CH. That statute talks about, basically, it begins with the question that's the issue for issue 8, how will the charges be allocated among retail customer classes? When I read that, that's in contrast with the staff's position to collect it on a basis of energy sales for all classes. To me, that's not an allocation among the classes. It's treating everyone as the same class and no allocation is taking place. Treating these securitized charges like the staff proposes, which is basically like an FAC charge, as I read their testimony, is not what the statute says to do. It's not based on determining the cost to provide the service for that particular class, and it's a design that is, if adopted, detrimental to industrial customers. I'll conclude by saying that when you determine the cost to be securitized, the company's allocation among these classes recovers the costs in a way that doesn't further penalize industrial customers who continue to bear a disproportionate share of cost, as shown in the class cost of service from the last rate case upon which the company's design in its direct testimony is presented. So I would ask the commission adopt what the company proposed in its direct testimony related to cost allocation. Thank you for your attention, and I'm happy to answer any questions.
Mr. Chairman, do you have any questions? All right. Any questions from the commissioners on the phone?
No questions, Judge. Thank you.
Thank you. And thank you, Mr. Opitz.
Can't turn it off. Thank you.
Okay. All right, the opening for Renew Missouri.
Good morning, and may it please the Commission. My name is Elisa Greenwald, and I'm here today on behalf of Renew Missouri Advocates, better known as Renew Missouri. Renew Missouri is a nonprofit clean energy advocacy group with a mission of transforming the state of Missouri into a national leader in clean energy. Because of this, our testimony in this case is limited to discussing securitization as it relates to the closure of the Asbury plant. As a brief overview, Renew Missouri believes that the facts in this case support a finding that utilizing securitization to recover costs related to the early retirement of Asbury is just, reasonable, and in the public interest. It is our position that denying Liberty's application based on the imprudence of its resource planning, investments in the Asbury plant, and investments in wind energy is improper, as these issues have been previously settled otherwise. Finally, we believe that the Commission has broad discretion to make this finding, a power that is separate from its general rate-making authority. To provide some background, the company first introduced the idea of retiring Asbury early in its customer savings plan of 2018. Following this, Liberty filed applications for and was granted a CCN to acquire 600 megawatts of wind resources. Then, in 2019, Liberty conducted its integrated resource plan modeling. Through this, the company found that retiring Asbury early would save customers a significant amount of money. This was largely due to the fact that the Asbury plant, even after extensive environmental upgrades, would have had to undergo another $20 million worth of environmental upgrades just to comply with the EPA's coal combustion residuals rule. In addition, in previous hearings, Liberty witnesses have testified that Asbury had significant non-fuel operations and maintenance costs that overwhelmed the plant's energy margins. As these issues have all been previously resolved in other dockets, Renew Missouri believes that the assertion of imprudence here is insufficient to reject Liberty's application, despite what the Office of Public Counsel asserts. Turning now to the securitization statute. The statute allows utilities a financial mechanism for retiring electric generating facilities prior to the end of their useful lives, and that is precisely what Liberty is seeking to do with the early retirement of the Asbury coal plant. In fact, this scenario is exactly what the Missouri legislature contemplated when it passed the securitization statute with overwhelming support. It is also worth noting that while this is the first case of securitization being used for the early retirement of a coal plant in Missouri, it has been used around the country to facilitate the transition away from costly and inefficient coal to cheaper and cleaner renewable energy sources. In passing this statute, the legislature also conferred upon the Commission broad discretion, separate from that of its general rate-making authority, to make a finding that the use of securitization is just, reasonable, and in the public interest. In previous cases, the Commission has found that there is a strong public interest in the development of economical renewable energy sources that provide safe, reliable, and affordable service while improving the environment. And the history leading up to this application demonstrates that Liberty is committed to furthering this public interest through shutting down dirty and uneconomic coal plants and shifting to cleaner, less costly energy sources. As Renew Missouri's witness, James Owen, testified in his pre-filed rebuttal testimony, the company's planning has demonstrated that it is listening to customer demands and that it places a value on environmental responsibility, two elements that contribute to the basis of a finding that Liberty's actions are in the public interest. Finally, it is key to note that the decisions the company has made leading up to this application have been found by the Commission to be reasonable and prudent. Taken together, Renew Missouri believes that these investments in the future of Liberty's customers support a finding that the use of securitization to recover costs related to the closure of Asbury are just, reasonable, and in the public interest. Thank you, and I'm happy to answer any questions.
Any questions from the commissioners?
Yeah, I have a
Chairman?
question. Thank you. On the issue of in the public interest, is it your position that that goes beyond purely economical issues in rates?
Yes.
Okay, thank you.
Any questions from the commissioners on the phone? Right, then, thank you.
Thank you.
An opening for staff?
Good morning. May it please the commission. My name is Kurt Stokes. I'm appearing on behalf of staff of the Missouri Public Service Commission this morning. I know everybody said it. I'm going to say it too. This is a first of its kind securitization hearing before the Missouri Commission. At its core, Missouri securitization statute aims for just and reasonable rates, and the Commission has been deciding just and reasonable rates for over a century. So a great deal of the issues in this hearing are what just and reasonable rates look like for Winter Storm Uri costs and for the retired Asbury plant. The securitization statute is just another tool in the Commission's toolbox setting just and reasonable rates. In deciding whether and how to use this tool, the securitization statute is aimed at answering two fundamental questions. First, will securitization save ratepayers money in the long run compared to traditional or customary rate making? Second, if securitization will save ratepayers money, how can the Commission and the utility structure the securitization to maximize those savings? The answers to those two fundamental questions should drive the answer to every other question before the Commission this week. For each issue we address this week, the Commission's decision should be guided on whether or not the securitization saves ratepayers money, and whether and how it will maximize savings to ratepayers. So big picture, as to the first issue, staff supports the Commission authorizing Liberty to use securitization to finance $262 million. This is the most just and reasonable sharing of Uri and Asbury costs between Liberty and its ratepayers. To arrive at whether and what amount the Commission should authorize to Liberty to securitize, the statute generally follows three fundamental steps. First, decide what Liberty would recover under traditional rate making or customary rate making. That's issues 2 and 3. The second step asks, what are the estimated upfront and ongoing financial costs and financing costs associated with securitization? That's issue 4. The last step is putting it all together, deciding what the quantifiable net present value benefits of securitization versus traditional customary rate making. And if so, I think you go forward with securitization. Now, Chairman Silva, you had a question earlier about, is $1 enough for the quantifiable net present value? Staff's position is that could be, but there are pros and cons that the Commission also should consider. And to the extent that they can be quantifiable, I think staff's expert Mark Davis can maybe help us track down the answers to some of these questions. One consideration is variable interest rates. So right now, the exact interest rate on the bonds is not known. It's only an estimate, and that's what we're basing that quantifiable net present value basis on. And so you do want some buffer there to know that the interest rate has to be below what would be the traditional recovery. Another one is, under traditional rate making over a period of 10, 13, 15 years, you might have different weighted average costs of capital, different costs of long-term debt, different interest rates that apply, and those are also unknown. And so to the extent that securitization can provide the benefit of kind of locking in a known interest rate at a given time, that's probably a quantifiable benefit for ratepayers. Especially if you're in an environment where you're expecting rising interest rates over the next 10 years or more. The tools to deal with that, the statute does require quantifiable net present value, but on top of that, The statutes and other commissions, what they've frequently done is required a certification from both the utility and the underwriter certifying to the commission that the interest rate achieved under the securitization bond does achieve a quantifiable net present value benefit. And that way going in, okay, we found a quantifiable benefit using the estimate, and now you're using the actual, that benefit is still there. And I think Liberty's testimony and staff's testimony have both supported that certification process to reassure the commission that if we do go forward, that there will be a certification that there's actual quantifiable benefits going forward. The other, the area where the commission's got a great deal of discretion is that finding the very first requirement for the commission's order that the issuance of securitization is just and reasonable. And, of course, the Missouri Supreme Court has said that the commission has a great deal of discretion in deciding what is just and reasonable. So hopefully that answers your question, and I think, with expert testimony from Mark Davis later, we can flesh that out a little bit more. Going to issue 2, this is what the just and reasonable amount that Liberty would recover for URI under traditional rate making. And the answer staff arrived at is approximately $193 million. In the absence of securitization, staff would recommend that Liberty be permitted to defer some of its extraordinary fuel and purchase power costs outside of its fuel adjustment clause, or FAC. Staff would recommend recovery of those amounts amortized over a 10-year period, and the 10-year period is because the sheer magnitude of those costs, the 10-year period helps to avoid rate shock. And staff would approve carrying costs based on Liberty's long-term debt rate. And this is probably where I should clarify now that staff is supporting the long-term debt rate at this point. Looking closer, staff realized that the short-term debt rate that staff arrived at of 3.5% was based on an annualization of what we thought was a monthly short-term debt rate of 0.3%. Staff now understands that the 0.3% is actually Liberty's annual short-term cost of debt. And frankly, 0.3% is just too low of a debt to recover over 10 years. It's just not just and reasonable. So I think this goes to also the commission's order asking questions, question 4C or D. Staff has now landed on a 4.56 long-term cost of debt as an appropriate carrying cost for traditional rate making. Staff, however, does not agree with the full amount of cost recovery for URI based on Liberty's filed position. The most important adjustment was to preserve the 95-5 sharing mechanism in Liberty's fuel adjustment clause. Now, Liberty just got up and said that it's unlawful to not share that. But the lawfulness comes from that just and reasonable requirement. And the very first requirement the commission finds is that the cost sharing has to be just and reasonable. And since 2008, the commission has always found the 95-5 sharing mechanism is just and reasonable. And it's necessary to ensure that Liberty is sufficiently incentivized to make prudent and economic fuel and purchase power decisions. Second, sharing of some costs associated with natural disasters is consistent with previous commission decisions involving natural disasters. The just and reasonable standard allows the commission to share this. The requirement that costs be extraordinary, that just gets Liberty through the door. That's what allows them to qualify it as an extraordinary cost. It doesn't mean that they automatically get to recover that. And that's supported by the Missouri Supreme Court decision in 2021 in Spire's rate case. There, the Missouri Supreme Court firmly rejected the idea that utilities are automatically entitled to recover all prudent costs. The Missouri Supreme Court held the commission has great discretion in allowing or disallowing costs based on that just and reasonable standard, whether or not those costs are prudent. The last thing to keep in mind with that 95-5 sharing mechanism is you have to remember, in case ER 2022-0332, that's Liberty's FAC filing. When Liberty first came to the commission asking to defer URI costs, there was an issue. OPC raised an issue about where are you set the dividing line between what costs are extraordinary and what were not, and what was going to flow through the FAC and what was going to be deferred. Staff does have OPC's filing and the Commission's order in that one as available as a demonstrative exhibit if you are interested in seeing it. The problem with Liberty's position is if Liberty is allowed to collect 100% of its extraordinary costs from URI, we're going to create perverse incentives. And the next time that there's an extraordinary event with extraordinary costs, public counsel, other ratepayers may intervene and try to push the threshold for extraordinary costs as high as possible to preserve that 95-5 sharing mechanism. And that really goes against the purpose of the statute, which is just, again, that goes back to that first fundamental question: is securitization going to save ratepayers money? And you know, if ratepayers are in here saying, well, to preserve that 95 sharing mechanism, we've got to, you know, raise that threshold on extraordinary expenses, that's going to create rate shock, or create the risk of rate shock. Frankly, it just puts ratepayers in kind of a Hobson's choice where, you know, heads Liberty wins, tails ratepayers lose. So that's really the just and reasonable reason to preserve that 95 sharing mechanism, is to avoid this issue in the future. And it really is, you know, when you look at all of the URI costs, it's a $10 million sharing of costs. So staff is asking ratepayers to pay approximately $193 million, and asking Liberty to share only 5% of that, or $10 million. And that is just and reasonable sharing. The second most important adjustment to make for URI costs is to consider Liberty's higher than normal revenues Liberty received during URI. Now, Liberty didn't address this in their opening, but it is an important issue. This amount, approximately $3 million, has to be considered together with Liberty's higher than normal costs during URI. And it is authorized by the statute. The securitization statute specifically requires just and reasonable rates. And just and reasonable rates always requires a comparison of looking at costs and revenues together. That's what the Commission does in every rate case. And again, whatever amount of savings and securitization, whatever that might entail, ruling in staff's favor on this issue ensures that securitization does not take away that $3 million and benefits the customers would normally have benefited from under customary rate making. The third adjustment to make for URI costs is to consider that Liberty failed to properly test and tune its Riverton 11 unit. For years, Liberty's ratepayers have paid for Riverton based on its status as a dual fuel unit capable of running on fuel oil when natural gas supplies were interrupted. Liberty listed Riverton 11 as a dual fuel winter resource, both with a Southwest Power Pool and with the Commission and its Integrated Resource Plan, or IRP. Yet in 2021, when URI hit, Riverton had not been properly tested to run on fuel oil since 2016. In addition, Riverton was tuned to 70 degrees, which is not appropriate for a resource listed as a dual fuel winter peaking resource. In the end, Riverton was unable to start and run on fuel oil during URI, and the Commission staff is asking that the Commission make approximately $2 million adjustment to benefit ratepayers based on that adjustment. With regard to other issues, staff does not recommend a disallowance based on Liberty's resource planning, and staff does agree that, you know, the decision on whether it's reasonable to retire Asbury is properly before the Commission, and we agree with Liberty's analysis that the Commission does have to find that it's prudent in order to qualify as an energy transition cost. The only difference the Commission staff has with the Office of Public Counsel has to do with income taxes. Staff does not recommend an adjustment based on OPC witness Mr. Riley's testimony at this time. The tax consequences of URI are not currently known, and the exact amount of taxes that Liberty will be required to pay on securitized utility tariff charges are also unknown. And regardless of the Commission's decision on this tax issue, however, the tax consequences should be accounted for in a future rate-making reconciliation process as required under Section 393-1700.2 sub 3 sub c sub k. The last two issues to decide on URI are carrying costs and the appropriate discount rate to use. Now, as I indicated earlier, staff has realized that the appropriate carrying cost from the time that URI occurred until the time that the costs are securitized should be 4.65%. That is based on Liberty's long-term debt rate. And again, we don't support a full weighted average cost of capital carrying cost, and that goes back to the just and reasonable, just a sharing of some expense between ratepayers and Liberty for extraordinary costs. And then when you're looking at the discount rate on URI, staff does not disagree that 6.77 is a useful comparison tool, but the long-term debt rate of 4.65% is also helpful. And under most reasonable assumptions, we can run through those probably when Mr. Davis is testifying. Even a long-term debt rate of 4.65% as its count rate, you're going to arrive at quantifiable net present value benefits for ratepayers. That moves us on to the next issue, and again, we're talking about customary rate making, traditional rate making, and what Asbury cost would Liberty be allowed to recover under traditional rate making. For this number, staff arrives at $69 million, give or take. In the absence of securitization, staff would recommend a 13-year recovery period, as Liberty does. In Liberty's most recent rate case, staff recommended no return on the undepreciated Asbury amounts, only a return of. However, on a net present value basis, the difference between a return on and a return of is only approximately $1.8 million. Moreover, to the extent that the Commission would approve a return on Asbury, the interest rates on bonds would be expected to have a much lower rate than the weighted average cost of capital return, both in this most recent rate case and in future general rate cases. Staff recommendation is based on the requirement that some sharing of plant that is retired early and therefore no longer used and useful is just and reasonable and the most appropriate in setting just and reasonable rates. Staff's net book value of the retired Asbury plant is just over $159 million. And I believe there was a Commission question about how staff arrived at that. The brief answer, but we can have Amanda McMillan testify more into detail on this, is that staff agreed with Liberty's calculation of the net book value. The difference is the value of that AAO regulatory liability, which staff calculates as approximately $76 million. And staff urges, and it emphasizes, that it is just and reasonable to allow Liberty to recover some portion of the net book value, but that the regulatory liability of $76 million, which represents money that ratepayers have already paid to Liberty for Asbury costs, that also gets a return on at the weighted average cost of capital. Second, staff's biggest adjustment is to correctly calculate the ADIT credit and excess ADIT credit due to customers under the securitization statute. Witness Charlotte Emery, testifying for Liberty, effectively discounts Liberty's ADIT and excess ADIT balances twice. Now, what ADIT represents is it's accumulated deferred income taxes, and this is money that ratepayers for Liberty have already paid to Liberty for taxes that Liberty has not yet incurred. And the idea with ADIT is that the amounts that customers pay early on are eventually returned as those taxes are paid. What Liberty has done is ignored the income side of the equation. They've only looked at the rate base side of the ADIT. And as a result, what Liberty's position really is telling ratepayers is, acknowledging that ratepayers have overpaid $36 million to date for Asbury costs, and rather than returning that $36 million over a certain amount over the next 13 years, as would normally be done in rate making, Liberty only wants to return $5 million of that, and they do that by discounting it twice and ignoring the income side of the equation. Now, the other difference that accounts for staff's ADIT difference is staff's ADIT, we start at $22 million. The current value is $22 million. The net present value of that is $17 million. But even if you agree with Liberty's ADIT calculation of $36 million, the net present value of that is $22 million. So if you agree with Liberty on the ADIT issue, on the ADIT balance of 36, we ask that the net present value of that be 22 million. If you agree with staff's ADIT level, we ask that the net present value be 17 million. PC witness John Riley, staff disagrees that Mr. Riley has followed the statute and disagrees that his position on ADIT and excess ADIT are supportable by the record. Staff disagrees. We don't think that the clock stops on deferred taxes once plant associated with that tax is deferred, and that's because Asbury was included in rates in the 2019 rate case and was included all the way up until the end of May of this year. Third, staff initially, we do not recommend that Liberty be allowed to securitize its asset retirement obligations for asbestos removal or coal combustion residuals, also known as CCR impoundment. Staff's position, however, would not preclude Liberty from recovering those amounts once they are actually known and knowable and measurable by documentation. Staff witness Kim Bolin will testify. I believe there were some documents that Liberty witness Mr. Landau provided in server rebuttal testimony that could probably get Ms. Bolin closer to Liberty's asset retirement obligation calculation, but you know, for hearing purposes, you know, the statute requires that Liberty support its case with documentation, indirect testimony filed with the case, and not in server rebuttal. The statute does talk about estimates, but where it asks for estimates, it asks for estimates, and when it asks for, you know, energy transition costs, other than interest rates, it's not asking for estimates for that. Finally, I'm sorry, not finally, fourth, staff believes that decommissioning costs should be set at $1.3 million, not Liberty's proposed $12.4 million. Staff's position is based on the note that Liberty's projections failed to reflect any salvage value that Liberty will receive from the demolished Asbury asset. Fifth, staff believes that the depreciation expense should be based on an effective retirement date of December 2019 and not March 2020 as proposed by Liberty. The resulting depreciation rate is expense is $24 million through April 2022. Staff witness Amanda McMillan can testify about the reasons we believe Asbury was retired in December 2019, but it's really because Asbury stopped producing energy for customers in December of 2019. They had no coal on hand in January of 2020. They had no coal contracts for coal in January 2020. Sixth, and finally, Liberty should be allowed to recover $2 million in carrying costs for Asbury. Given the short period of time the costs are due to be applied, and remember, Asbury was included in rates all the way up through May of 2022. So when Liberty is securitizing Asbury costs, the so-called carrying costs, we're only calculating June of 2022 through whenever they actually get these bonds issued. Assuming that's December 2022, that's only 6 months. That's why staff believes that Liberty's long-term debt rate of 4.65 is more appropriate here than the full weighted average cost of capital. As to the remaining proposed adjustments to Liberty, staff generally agrees with Liberty's filed position and does not support many of the adjustments proposed by the Office of Public Counsel. Getting to the proposed discount rate to arrive at a net present value of Asbury, staff agrees that the weighted average cost of capital of 6.77% is appropriate. So in summary, staff proposes customary or traditional rate making recovery of $262 million, $193 million for Uri, and $69 million for Asbury. Okay, that gets us back. That's traditional rate making. That's the first step under the statute. The second step is to decide, okay, can securitization, beat that? Can securitization beat traditional rate making? And to figure out that, we have to figure out, okay, well, what are the financing costs? And this is where Mr. Davis can really testify Thursday about the benefits of a combined offering. Many of the benefits of a combined offering come from the elimination of redundant fees for experts and, you know, underwriters and all those things. I would encourage the commission, I think I will also ask, kind of, you know, up to date, you know, what are the costs that have been incurred to date, and, you know, has Liberty been avoiding duplicative costs to date? You know, there was some concern earlier in the summer with the volatility of interest rates that if we issued a consolidated order, that you might be forgoing the opportunity to lock in a lower interest rate on some non-contested issues. But seeing as how we're hearing today on the full rate case, I think, you know, staff agrees with Liberty. I think all the other parties that, you know, it really does make sense to do a consolidated order and a consolidated bond offering in these cases. Staff does agree with Liberty that even with the additional financing costs and other transactional costs associated with financing through securitization, the securitization does provide a quantifiable net present value benefit to customers. And based on staff's proposal of using a 4.65% discount rate for URI and a 6.77% discount rate for Asbury, that there would be roughly $25 million in savings associated with securitization of URI and Asbury together. And that's issue 5. That's putting everything together. You know, based on most reasonable assumptions, there would be a quantifiable net present value benefit, and securitization is just and reasonable. Taking that conclusion from issue 5, staff's conclusion on issue 1, you know, how much should Liberty be authorized to securitize? That flows, and the answer is $262 million. But I want to emphasize this. $262 million is the amounts that are just and reasonable for Liberty to recover under any circumstances. Because these are the just and reasonable amounts to allow recovery of outside of securitization, they are also the just and reasonable amounts under securitization. The purpose of securitization, remember those two fundamental questions. Will securitization provide a benefit to customers? The purpose of securitization is not to allow the lower interest rates associated with securitization bonds to allow a utility to fit in recovery of cost or expense items that would not otherwise be allowed, or in addition of what the commission would otherwise find just and reasonable. Now, having answered that first fundamental question in the statute, will securitization save customers money? Let's move then to the next question. How can the commission maximize those savings? This is issues 6 and 7. Issue 6 asks whether the commission should designate a commission staff member advised by a financial advisor, and what role should the designated staff and financial advisor have. First, staff believes that the commission should designate a commission staff member to be advised by a financial advisor. Doing so is essential, one, because, again, this is the first of its kind before the Missouri Public Service Commission. And so having a designated staff member advised by a financial advisor is really going to be key to understanding and explaining and responding to that issuance advice letter that will be coming down once the bonds are issued. In evaluating all of the assumptions and all of the calculations that go into that issuance advice letter, it's really going to be key that there is a designated staff member and a financial advisor who can advise the commission on that. The second reason is that the presence of a designated commission staff and financial advisor is essential to protecting ratepayer interests. Under Liberty's proposal, ratepayers are not directly protected, even though ratepayers and not Liberty will be irrevocably responsible for all charges associated with securitization. Without that same irrevocable obligation, Liberty and all the other parties involved with the bond issuance process just simply do not have the same incentives to protect ratepayers that ratepayers themselves have. Now for issue 7, what conditions should the commission issue that are not in violation, that are not inconsistent with the statute? First, the commission should clarify that any designated commission staff and financial advisor do have the right to representation by legal counsel in the process. This condition is not inconsistent with the securitization statute, because nothing in the securitization statute prohibits staff or the financial advisor from legal counsel. And nor could a prohibition of legal counsel be read into the statute, because the ability of any party to any commercial transaction to have a lawyer is so presumed in the law that you'd have to have something explicitly saying somebody did not have the right to an attorney before you could read it into a statute. The second condition, the commission should clarify that it should have an active and specific role in the issuance process. And that involvement should be aimed at avoiding the drastic and catastrophic rejection of the issuance advice letter. The commission should ask for regular progress reports and update reports, weekly, sometimes even, or maybe even more than weekly, as necessary, depending on the speed that the bond issuance goes. Using staff's designee and the financial advisor to file those regular reports and keep the commission updated on the status of that will be important. Third, as Liberty also proposes, the commission should order both Liberty and its underwriters to certify to the commission that the proposed securitization meets the requirement that the bonds, as structured, do provide quantifiable net present value benefits to ratepayers, and that the bonds are structured, marketed, and priced to provide the lowest securitized utility tariff charges consistent with market conditions at the time the bonds are priced. Fourth and finally, for conditions, the commission should order that staff and its financial advisors, as represented by legal counsel, do be involved in the selection of the underwriter and any other member of the syndicate group. And the idea here is to get as broad and diverse input of opinions and strategies as possible to really find the optimum path for getting these bonds to market. Issue 8, and I apologize for this was added so late on Friday evening after close of business hours, but staff does propose that costs be allocated on the basis of loss-adjusted energy sales. Staff witness Sarah Lange will be able to explain how that energy allocation is an allocation among customer classes. I think we're going to identify problems with Liberty's proposed allocation. One which jumps to the top of my mind is that it doesn't include EV customers. So under Liberty's proposal, there's an entire customer class, maybe more than one customer class that has no allocation whatsoever. And the energy allocator takes care of that. Staff witness Jay Luber will also be able to testify that the decision to retire Asbury really is tied to the decision to bring in renewable wind resources and to replace Asbury plant with the and so the idea of tying the burden of the Asbury retirement costs to the benefits of the wind, you're tying together the allocation of remaining costs with the allocation of the benefits of the retirement of Asbury. And that position is consistent with Renew Missouri, who has talked about the decisions of Liberty to use wind instead of Asbury. It's consistent with Liberty's initial filed position, where they justify the reasonableness of retiring Asbury based on the economics of wind versus the economics of coal. It really was, based on Liberty's own filed position, the reason they retired Asbury was that the wind was going to be more efficient. And so that is the basis for staff's allocation. Thank you for your time this morning, and if you have any questions, I will do my best to answer them or let you know who the witness is who probably can.
Thank you. Mr. Chairman?
Thank you. Thank you. First, I appreciate you proactively addressing some of my questions on the quantitative benefits. Addressing the issue of one order versus two orders. Staff's position is that the preference would be for one order.
Yes.
Is staff not concerned that an appeal may delay or cause issues with the non-contested issues if they're all in one order?
Initially, we were. Our witness, Mark Davis, ran a few scenarios and kind of showed, if you did a consolidated order and you delayed the securitization of some, something that was not up on appeal, what does that look like? You still see a net present value benefit, even with a delay associated with one piece or another. And because you do still have the cost savings, avoiding duplicative costs associated with consolidation, even that delay is there. That's not to say that there's no risk with a delay. If interest rates became far more volatile, for example, in the future, that might risk some things. So it's not risk-free, but, I think in the balance, staff's current position based on, I think a conversation I had Friday, that the market conditions now are still supportive of a consolidated order.
Okay. And then, does staff believe that the commission has a legal basis to reject the securitization of Asbury, as OPC suggests?
So a legal bit, yeah. So the energy transition costs, the retirement of Asbury does have to be found just and reasonable and prudent by the commission. Staff doesn't oppose Liberty's evidence that the retirement of Asbury was prudent. The basis for staff's adjustment to Asbury is the used and useful standard. And that's consistent with staff's testimony, both in the rate case and here in the securitization case. And, it's unfortunate that Erie happened, but it's also, it's a really strong illustration of why it's just and reasonable to have some sharing of costs. Because when you look at when Erie hit, Liberty ratepayers were paying for all of Asbury. They were paying for Asbury as if it was there. And Asbury wasn't there providing service during Erie. And so there really should be some sharing of costs under that used and useful standard. So that's the basis for staff's adjustment, and it goes back to the just and reasonable standard, and that's that's the first finding that the commission's order has to find under the securitization statute, is whatever securitization amounts there are, that it is just and reasonable, and that's the basis for staff's proposal.
Okay. Thank you. Thank you, Judge.
Thank you. Any questions from commissioners on the phone?
No questions, Judge. Thank you.
That was Commissioner Holtzman. All right, thank you.
Thank you.
Then opening for public counsel.
May it please the commission, my name's Nathan Williams, and I'm representing the Office of the Public Counsel here today. Public counsel is not opposing securitization per se, and the commission should take note that Liberty's actions towards Asbury and when it incurred Storm Erie costs preceded well the securitization statute under which it's proceeding here today. I want to point out that Liberty based retiring Asbury and replacing it with wind on its analysis projecting an expected benefit to retail customers of $93 million over 20 years. Starting in 2017, over the course of at least 4 cases, the Office of Public Counsel consistently has disputed the validity of Liberty's analysis, among other things, for undervaluing the cost impacts for the reliability of Asbury's availability to be dispatched to generate electricity at all times. Between these 2 securitization cases before you in this hearing today, Liberty is seeking to immediately receive $362 million in bond proceeds to be paid for by its customers over 13 years, plus interest. If you take $93 million and divide it by 20, that's $4.65 million per year. If you take $362 million and divide it by 13, that's $27.85 million per year. In Liberty's most recent general rate case, it received a $35.5 million increase, which it described to be a 7.38% increase. These bonds, in terms of bill impacts, will be on the same order of magnitude, probably something like a 6 or 7% increase, if you give Liberty everything it's asking for. Public counsel agrees with staff that what you measure against for deciding whether or not securitization benefits customers is what would Liberty recover otherwise, and that would be in a rate proceeding. While the Commission cannot be arbitrary and capricious, as in a general rate case, it is within the Commission's discretion here to decide how much of the $362 million Liberty is entitled to recover from its Missouri retail customers for extraordinary storm costs and no longer used in useful stranded investment. The extraordinary storm costs being due to Uri and the investment being due to its retirement of Asbury. The Office of Public Counsel is not claiming that Liberty's customers should not bear any of the $362 million in costs. It agrees Liberty is entitled to recover $69.5 million of them, but that Liberty has, for extraordinary storm costs, but that Liberty has over-recovered for its investment in Asbury by $24.2 million. And that the Commission thus should disallow Liberty recovery of its 2015 environmental upgrades for its stranded investment in Asbury. As to Storm Uri, Liberty's Missouri customers should not be responsible for all of the over $193 million Liberty paid for electrical energy in the SPP market during Storm Uri that it is seeking to securitize. Not only is Liberty compensated for this risk of such events through the Commission-allowed return on equity, as public counsel witness Lena Mantle explains, if Liberty had continued to manage its electrical resources portfolio to reliably provide at all times the electricity its customers demand, rather than try to generate more revenues from energy sales in the SPP markets than Liberty's cost to make those sales, what she describes as beat the market, then Liberty would have had sufficiently reliable dispatchable resources such as its retired Asbury plant that had coal on site, so that rather than overexposing its customers to SPP market prices when they skyrocket, those customers would be responsible for Liberty's cost of obtaining energy from that resource. Based on Ms. Mantle's analysis, the impact of Liberty's imprudent resource planning on its Storm Uri fuel and purchase power costs is $67 million. As public counsel witness John Robinette and staff witness Jordan Hull assert, Liberty's customers should not be responsible for costs Liberty could have avoided had it prepared and run its Riverton 11 unit during Storm Uri. As public counsel witness Lena Mantle and staff witness Brooke Mastrogiannis, which her testimony is to be adopted by staff witness Brad Fortson, explained, Liberty's customers should not be responsible for more than 95% of Liberty's prudent fuel and purchase power costs during Storm Uri. As public counsel witness John Riley explains, Liberty's Storm Uri costs should be offset by its Storm Uri income tax deduction. Because Liberty's Storm Uri fuel and purchase power costs are expenses, public counsel disagrees with Liberty that its carrying costs should be based on Liberty's weighted cost of capital. Instead, as public counsel witness David Murray testifies, they should be based on LUCO's average short-term debt rate for each month from February of 2021 through the date the securitized bonds are issued. Further, Liberty should not be rewarded with a higher carrying cost rate for delaying its application to securitize those costs. As to Asbury, public counsel witness Lena Mantle explains that Liberty changed its resource planning from a focus on its customers paying the lowest cost for reliable energy to Liberty's cost of energy it sells into the SPP market being on average lower than the SPP market price, beating the market. The risk of following that approach is demonstrated by Liberty's actual fuel and purchase power costs for Storm Uri, and is a basis for disallowing Liberty recovery of up to all of its stranded investment in Asbury. Public Counsel witness Jeff Mark points out that the replacement generation provisions of the securitization statute envision a one-for-one replacement based on the undepreciated investment in the replaced generation. When Liberty retired Asbury, it had about $200 million in undepreciated investment in Asbury. The investment in the wind farms with which Liberty replaced Asbury is $1.2 billion. That is a 6-to-1 replacement, not 1-to-1. Not only are Liberty's customers now paying significantly more in rates for less reliable wind supply-side resources, Liberty is seeking to recover its undepreciated investment in Asbury when it is neither used nor useful. Dr. Mark further explains that not only has Liberty shifted all of the risk of the adequacy of its electrical energy resources to its customers, it is still pursuing recovery of its investment in its air quality control system in Asbury when it, Liberty, voluntarily chose to shut Asbury down after only realizing about 5 of the 20 years of anticipated life of that investment. Dr. Mark recommends that the Commission not allow Liberty to recover the net plant balance of its investment in that air quality control system measured as of January 1 of 2020. As Public Counsel witness John Riley explains, Liberty's Missouri retail customers have more than fully compensated Liberty for its self-stranded investment in Asbury by how much they have paid Liberty for Asbury and their electric bills over the past 2.5 years since Liberty last ran Asbury on December 12th of 29, a sum that amounts to about $24 million. I mean, overpaid by $24 million, pardon me. As Public Counsel witness John Riley and David Murray assert, Liberty has overstated what carrying costs the Commission would ascribe to its unrecovered investment in Asbury when Asbury is no longer used and useful, and Liberty voluntarily chose to remove Asbury from service shortly after doubling its investment in Asbury. Moreover, Liberty could have realized any recovery of its stranded investment in Asbury when rates the Commission would give it as early as September 16th of 2020 when rates from case number ER-2022-0374 took effect. Instead, Liberty successfully advocated the Commission not to decide the rate impacts of it retiring Asbury in that case. The Office of Public Counsel recommends that you find there are no costs left to securitize for Liberty's investment in Asbury and that no more than $60 million of fuel and purchase power costs can be securitized for Storm Uri. As I indicated earlier, Public Counsel agrees with staff that the measuring stick against which you evaluate whether or not bond securitization is beneficial over other recovery is what would happen in a rate case on these issues, what the Commission would do. And the Commission has broad discretion in doing so. It's not necessarily limited to a prudency determination. Are there any questions?
Mr. Chairman?
Thank you. Thank you for your opening. I do have a question just to make sure I'm following, and forgive me if I oversimplify your argument here. So you agree that Liberty should be entitled to recover, for round numbers, $69 million for Winter Storm Uri, but you're wanting to subtract $24 million for what you say they over-recovered for Asbury.
We put that out as a position, yes.
Does the securitization statute contemplate that type of an equation, pitting one type of securitization against the other?
I don't know. I don't know that it does. We've also put out alternatives for dealing with the over-recovery. deal with it in a future rate case or in some other fashion.
Okay. And on the issue of the environmental compliance costs,
The AQCS from 2015, is that what you're referring to?
I believe so. The cost that they invested in Asbury before they retired it for environmental compliance.
Well, they made many investments in Asbury over time, but the most recent one for environmental compliance that were the large number of dollars that basically doubled their unrecovered investment was the AQCS in 2015.
So are you asserting that the company surreptitiously inflated their stranded costs?
No, our position is that it's not fair to customers to bear 100% of the costs, and what the commission should disallow is what Liberty had not recovered for the AQCS beyond the 5 years that it actually was used and useful.
Is the commission required to look at those costs based on available information at the time that the costs were incurred?
We're not disputing the amount of the costs. We're arguing what the commission should do with them in terms of allowing cost recovery. Basically, Liberty was going down the route of maintaining that reliable, dispatchable coal plant, and then suddenly 5 years after, well, 4 or 5 years after it put it into service, it shut it down. You know, you can look at it as tied to building wind, you could look at it as independent, but the bottom line is it shut that coal plant down. And the impact, my understanding, was about reducing interconnection costs for one of the Missouri wind farms by $20 to $30 million. They could have kept that up and running and had it as a reliable resource. I mean, one thing that makes it very reliable is the fact that it has fuel on site. We saw what happened with Storm Uri, both in Missouri and Texas, with gas supply, and we saw what happened with how much wind power was generated.
But you're not making a prudence argument.
Our prudency argument is that their resource planning wasn't prudent because it was not, Liberty was not focusing on keeping a good mix of reliable resources. Now, Asbury would have been a unit that fit that criteria, but there were other things potentially that could have.
Was any of the Asbury infrastructure used to connect the
Yes.
wind to their system?
Yes.
And
One of them.
so should those costs be allowed to be securitized?
My understanding, those costs were dealt with in the rate case. It was not retired plant. It was kept in as a used and useful plant, is my understanding, because it's being used as part of one of the wind farms.
Okay. Thank you. Thank you, Judge.
Any questions from the commissioners on the phone? All right, then thank you.
Thank you.
That's all the openings, and it's about time to break for lunch. So we'll take a break now. We'll come back at 1 o'clock.